Is this my mark? We're making a video of this which will no doubt be sold to frat houses for late night viewing over Budweiser. It's a substitute for video nasty. But anyway, I want to talk to you about some recent contract cases. In Alice Through the Looking Glass, there's a well-known exchange between Humpty Dumpty and Alice, and Humpty says, when I use a word, it means just what I choose it to mean, neither more nor less. And Alice says, well, isn't the question whether you can make words mean so many different things? And he says the question is, which word is to be the master? And the three cases I'll be talking about, they're all about words and words being used in different ways. And the three cases have been identified in the extremely discursive handout which you'll find at the back of your pack. And the first of those cases is a case called Barclays Bank against Unicredit. And it's about the word reasonable. And the idea of behaving reasonable is something that's familiar in English law. But in point of fact, if you look at all the cases and all the authorities, reasonable is used in different ways, in different contexts. Context is everything in contractual interpretation. Now, in this case, Barclays and Unicredit entered into a synthetic securitization back in 2008. It's very complex. We don't have to describe the details of these complex financial arrangements, but believe me, they're difficult to understand. Anyway, Unicredit wished to determine the arrangement prematurely, and Unicredit was able to do so, but it was subject to the consent of Barclays. But Barclays' consent had to be determined in a commercially reasonable manner, and the question before the court was, what did that mean, determined in a commercially reasonable manner, and especially in the context of a commercial finance document? What test did you apply? Now, Unicredit, who wished to terminate the arrangement, said that you had to look at reasonableness in a very broad way, balancing interests of Unicredit, balancing interests of Barclays, and so on. In point of fact, there were two major arguments which a court considered, one of which won the day. The first argument, and it was advanced by Barclays, was this: the determination whether or not to give consent was effectively a power reserved to Barclays under the contract. And there's lots of English law which says that if you have a power in a contract, you can exercise that power however you wish. Reasonableness doesn't really enter into the equation, except in this sense, that you can't exercise the power capriciously. You can't exercise the power in bad faith. That's what reasonableness means when you're exercising a contractual power. That was argued very forcefully on the part of Barclays, but that argument was rejected. But the second argument won the day, and the second argument was this: when you look at commercial reasonableness, it is an objective test, but you have to look at the landlord and tenant cases. Often, when you're dealing with a lease can be assigned, but subject to the landlord's consent, the consent not to be unreasonably withheld. But in considering whether or not it is reasonable, unreasonable to withhold consent, you don't go through a balancing exercise. The landlord, or in this case Barclays, they don't have to justify their reasoning. And likewise, in looking at it objectively, you can have regard to the fact that the person who has to give or withhold its consent can take into account their own interest. And in this case, it was perfectly legitimate in deciding whether or not Barclays had reasonably or not reasonably withheld its consent, to have regard to the fact that Barclays thought it was in its own interest for various reasons not to give consent. And that was something to be taken into account. In looking at whether or not a decision taken under a contract, even a commercial contract, has been taken in a reasonable manner, you can expect the party with the power to give or withhold the consent to have regard to its own interests, to be partisan even, to even regard its interests as paramount to the exclusion of the other party. The only difference will be when it takes into account its own interests in a wholly disproportionate way, in a way which throws the contract completely out of kilter. And on that basis, it was held that Barclays had the right to withhold the consent because it did not regard its interests as being served. And in doing so, it was acting in a commercially reasonable manner. So it's quite an important case because it's transporting notions which we're familiar with in the context of landlord and tenant to commercial contracts. Okay, second word, representation and warranties. And this is another case. This is a case called Sycamore Bidco against Breslin. Now, in this case, there were representations and warranties. It was a share purchase agreement that was in dispute. And the argument was that the purchaser had a claim against the vendor on the basis that various warranties had been breached. Warranties which were set out in the share purchase agreement itself. But the purchaser had another argument up its sleeve, and it was this: look at these warranties. These warranties are more than just warranties. They're cold warranties, warranties that the accounts presented a true and fair view of the company's business. What's more, they embody representations. And they embody representations in such a way that we can bring a claim not only for breach of contract, for breach of warranty, but also for misrepresentation under the Misrepresentation Act, or for negligent misstatement. Look, they are warranties, they're contractual warranties. They're saying that the accounts are true and fair. But obviously, in getting to those warranties, you've got to suppose that representations were made beforehand. You've got to imagine that representations induced those warranties to be given. And therefore, we have a separate claim for misrepresentation. Why did it matter? It mattered in this respect because a claim for breach of warranty, you're entitled to damages based on the suppositions that the warranties proved to be true. A claim for misrepresentation or misstatement, you're entitled effectively to unscramble the entire contract, and damages are calculated from a different base. So if the purchaser had succeeded in this argument that the warranties embodied within themselves representations, the damages would have been greater. The court rejected that argument. Mr. Justice Mann had carried out a very detailed contractual analysis. But then he said this, he said that all things being equal, where you see a warranty in a contract and there's no evidence of any pre-contractual representation, you're just relying upon the warranties, you have a real conceptual problem, because a warranty is a warranty, that's embodied in the contract, whereas representations, you expect them to come before the contract, to induce the contract. And so to imagine that warranties were in fact representations, that's a difficult leap to make. Of course, in your contract, you can characterize a warranty as also a representation, but if you don't do so, you're faced with the difficulty of this case. You can't infer from the warranty a representation. And in coming to that view, Mr. Justice Mann rejected the decision of another judge, a judge called Mr. Justice Arnold. But the good thing was that the purchaser in that case succeeded in the claim for damages, succeeded in the claim for breach of warranty, and recovered substantial damages. Now, I feel a bit like an imposter talking about the Barclays Bank and Unicredit case and the Sycamore case, because they're two Addleshaw Goddard cases, both of which we won, in which I wasn't involved at all. So I'm talking through second-hand knowledge. But the lesson from those cases, I suppose, is that if we don't get you with a first barrel, we'll get you with a second. And in both those cases, we were successful. This is actually a third contract case, which was reported only last week, which we also won. But again, that's somebody else's case, and I haven't time to copy their notes of that case to talk about it here. But the third case I want to talk about, and the third word is guarantees, guarantees, guarantees. You know, what's meant by a guarantee? A guarantee can be a see-to-it guarantee, the guarantee given by your wife or your husband for your liabilities. I will see to it that my husband will pay off all his debts to his bank. It's a see-to-it guarantee. Now, those sort of guarantees are very delicate animals, and they can easily be upset. You know, and with those guarantees, if you guarantee your husband, and your husband has a defence to a claim against him from his bank, then you can avail yourself of your husband's defence. I guarantee that debtor. If he's got a defence, I've got a defence. You can also say that your guarantee has been released if, for example, there's been a variation or retirement or indulgence has been given to your husband's. These guarantees, these type of commercial instruments are, you know, rather like hemophiliacs, you know, the least bruising and, you know, it ends in disaster. But there's another type of guarantee. You still call it a guarantee, but it's a different sort of guarantee. And that's a guarantee where you're not really saying, if he's liable, I'll be liable. It's not an accessory obligation. It's a primary obligation. You're saying, I will be liable. I will pay you. And they're common or garden in the banking world, where banks guarantee demand guarantees, first demand guarantees, performance bonds, where a bank says, well, I will pay you. You've done your business with X. When you make demand of me, then I will pay you. And that's it. No questions asked. I will just pay you. They're different sort of guarantees. They're performance bonds, the first demand guarantees. Now, in a case called Wohan Goju Logistics, have you noticed my expert Mandarin pronunciation, against Impereki Bank of Greece, the question was whether the guarantee that had been given was the first type of guarantee or the second type of guarantee. What happened was the bank had given the guarantee and a demand was made of the bank to pay under the guarantee. And the bank said, hang on a moment, we're not going to pay because the party we're guaranteeing has a dispute with you who've called on us to pay under the guarantee. This is the first type of guarantee, and because the party we're guaranteeing can dispute its debt with you, we're entitled to run the same defences. We're entitled to run the same defences. The party claiming on the guarantee said, not at all. You bank said that you would pay. You bank said that you'd pay on first demand, and that was it. We're entitled to make that demand against you, and you are liable. And the fact that we're in dispute with the party you're guaranteed doesn't mean anything at all, has no relevance at all. We can be in dispute, but as long as we make a demand under our guarantee on you, and it's not a fraudulent demand, you have to pay. Now, the judge, to begin with, in the commercial court, an esteemed judge, Mr. Justice Clark, said he did a very careful analysis of all the clauses. He looked at 20 cases. You know, he looked at everything. Is it that sort of guarantee, or is it this sort of guarantee? Oh, and he decided it was the first sort of guarantee, and therefore he thought the bank was off the hook, because the bank could say, I don't have to pay immediately under this guarantee because the party I'm guaranteeing has a defence against your claims. I can borrow those defences. I don't have to pay you straight away. The Court of Appeal rejected that argument. Sorry. The Court of Appeal said, you don't look at these things clause by clause, bit by bit. It's really a blink test. Where you see a bank giving a guarantee in respect of a commercial transaction, where you see that payment has to be made on demand, you don't go into a nitpicking analysis of all the clauses, because the whole structure, the whole instrument indicates that's a first demand guarantee. And if the bank that has given the guarantee is asked to pay, and the demand is a conforming demand, the bank has to pay. And it doesn't matter that there might be a dispute between the party being guaranteed and the party calling on the guarantee. That's irrelevant. With these sort of first demand guarantees given by banks, you have to treat them like cash, like letters of credit, like done by letters of credit. They have to be respected. And all this sort of forensic nonsense, trying to work out just through looking at clause 7, looking at clause 9, that's nonsense. Isaiah Berlin distinguished between the fox and the hedgehog. The fox, he knew lots of little things, and the hedgehog, he knew one big thing. But the approach to these analyses is the hedgehog approach. What does it look like? What does it sound like? What does it smell like? And it was plainly a first demand guarantee, and the bank had to respect the demand and pay straight away. It's also an abject lesson in draftsmen being too clever by half. It was a first demand guarantee, but somebody had obviously got the guarantee books out and said, oh, this is a guarantee, so I've got to import all these clauses in. And of course they imported some clauses from the first type of guarantee, and that rather confused the issue. Anyway, that's
Well done.
10 minutes?
That's
Okay.
very good.